At 2 o'clock in the morning, a San Bernardino County Sheriff's Department deputy noticed Anderson's truck traveling in a high crime area with a partially obstructed license plate, something not allowed by California law. The deputy turned on his overhead lights to initiate a traffic stop, but Anderson sped up and made a series of turns ending up on a dead-end street. Anderson was detained. He told deputies that he wanted to park at a friend's house because his license was expired. The deputies confirmed the expired license and that Anderson was a career criminal. Anderson told deputies they could not search his truck, but the deputies said they needed to inventory the vehicle in order to tow it. Also worth noting, the friend whose house Anderson parked in front of didn't know Anderson at all and asked for the truck to be removed. While searching the truck, deputies discovered a handgun and arrested Anderson for being a felon in possession of a firearm. This week, we're going to talk about the United States versus Anderson, a 2024 Ninth Circuit Court of Appeals case related to inventory searches. I'm Steve Serbalik, and I'm a panel attorney with ASCOPS in Arizona.
Negative.
Anderson was arrested and sentenced to 77 months in prison. On appeal, Anderson argued that the deputies violated his Fourth Amendment rights when they searched his truck. Anderson felt that the deputies used the inventory of his vehicle as an excuse to search for evidence. As evidence of this, he pointed to the inventory sheet, which listed the gun the deputies located and the physical condition of the car, but did not list any of the other property in the vehicle, which included a watch, 2 pairs of Ray-Bans, and miscellaneous tools. The Ninth Circuit found that because the deputies did not conduct a vehicle inventory as required by the agency, and they were clearly suspicious of him beforehand, they used the vehicle inventory as a pretext to search for evidence. The Ninth Circuit decided in favor of Anderson. As I've said before, it's important to know your agency's policies and follow them for everything, but in this case in particular, for inventory searches. The courts have made it clear that failing to follow department policy is a relevant factor they consider as part of the totality of the circumstances in instances involving inventory searches. So, don't provide a way for criminals to get off the hook. Complete the paperwork, follow your policy, and don't take shortcuts. For my policymakers or labor group leadership out there, this may be the time to review your inventory search policy for your agency. The Ninth Circuit essentially describes San Bernardino's policy as not providing any leeway for officer discretion. Instead of policies that might say, deputies should, when practical, list items of value and remove the items of value for safekeeping and take steps to secure the vehicle. Instead, San Bernardino's policy said, deputies shall complete an inventory of any personal property contained within the vehicle. Strong, absolute language is sometimes tempting for leadership. It lets officers know exactly what you want from them. But including highly restrictive language in policy means that officers might unintentionally destroy a case. Imagine finding a murder weapon in a car, but the case gets thrown out because the officer didn't document every single item in this. But even if your agency's policy is poorly written or very restrictive, it's important to follow it all the time, but especially when conducting a vehicle inventory. If you have any questions or comments related to vehicle inventories, please leave them down below. Don't forget to like, follow, and turn on notifications. It really helps the channel grow. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching and stay safe out there.
Negative.